May it please the court, I am Gus Winter of the Nashville Bar. I represent Paul Chrisman in this case. The primary issue on this appeal is the trial court's Rule 56 dismissal on statute of limitations grounds of Mr. Chrisman's fraudulent concealment legal malpractice claim against attorney Keith Solomon.
Do you want to reserve any time?
Oh, I'm sorry. Thank you for reminding me. I would like to reserve 2 minutes, please, Your Honor.
2 minutes. Thank you.
The parties in this dispute entered into a tolling agreement, which in essence provided that any claims that accrued prior to November 27, 2016 were time barred if they were not filed before that date. The fraudulent concealment at issue in the present case took place in January of 2016 when Mr. Solomon deliberately withheld from his client, Mr. Chrisman, adverse financial information that indicated that Mr. Chrisman was going to sustain a significant financial loss if he agreed to give the putative buyer of his farm on an option contract an extension. In ignorance of that adverse financial information and in reliance upon Mr. Solomon's strong advice that he should grant the extension, Mr. Chrisman did so. Now, although the transaction took place in January of 2016, there is no evidence in the record that Mr. Chrisman had actual knowledge of the concealment of financial information on the part of his lawyer in January of 2016.
Counsel, is the financial information here that instead of, and I may be getting my numbers wrong, so please correct me if I am, 170 houses, they're going to be under 135 houses? Is that the financial information that was concealed?
Yes, Your Honor. Basically, what Mr. Chrisman did not know, and which his lawyer did, was that there was likely to be a substantial reduction in price under the option contract because the option contract price was based upon the number of lots. Now, the traffic study report that was commissioned by the prospective buyer indicated that there was going to be a big reduction in the neighborhood of a third of the number of lots.
I thought the defendant in this case, though, put forward as undisputed facts that this information had been shared in, I may get my months wrong here, but September or October of 2016 at the latest. Is that, am I wrong in terms of the defendants asserted that as an undisputed? And I thought your client had essentially agreed that that was the case.
What happened was in the summer of 2016, Mr. Chrisman was informed that the Williamson County Agency had issued a permit for a number of lots that was going to entail a reduction. Mr. Chrisman's first knowledge that that was coming was when he received that indication in the summer of 2016. There is no knowledge that he was aware that there was going to be a substantial reduction in the number of lots in January of 16. And as a matter of fact, it's in the record that Mr. Chrisman had a prospective buyer who in February or March of 2016 was prepared to meet or exceed the sales price under the existing contract.
Can you walk me through then, is my understanding, one of the undisputed facts is here is at the time he signed the extension, and we're referring, I guess, to September 2016, it appears from the previous provision, Chrisman was aware that the number of lots had been reduced from 175 to 130. And the response is, from your client, undisputed for purposes of this motion. So doesn't that mean it is undisputed for purposes of the summary judgment motion that he was aware as of September 2016 that the number of lots was going from 175 to 130, or what am I missing there?
Okay. What you're missing is he didn't know that in January, and he granted the prospective purchaser the extension in February. If his lawyer had told him in January, look, you're going to take a cut. You're not going to get the kind of money that you think you're going to get under this contract. Mr. Chrisman had an opportunity to refuse to grant the putative buyer the extension. If Mr. Chrisman had done that, he would have realized, he would have found a different purchaser who would have paid more money. So the point is not what he knew in the summer of 16. The point I'm making, Your Honor, is if he had known that when his lawyer knew it, he, Mr. Chrisman, could have refused to grant the extension to the first buyer and found a replacement buyer and gotten a better price under a different deal.
And what proof is there in the record that Mr. Solomon was aware of that in January of 2016 and withheld it from Mr. Chrisman?
There is email correspondence in the record between the putative buyer and Mr. Solomon and the company that did the traffic study that there was going to be a substantial reduction in the number of lots that Williamson County was likely to approve. So Mr. Solomon, through the email correspondence, had that information. There is no information in the record that he shared that information at the time that Mr. Chrisman absolutely needed to hear it. And I would add, there is nothing in the defendant's statement of undisputed facts that suggests that Mr. Solomon communicated that information to Mr. Chrisman at the point that Mr. Solomon learned it. We also have an affidavit from Mr. Solomon when he says absolutely nothing about whether he told Mr. Chrisman in January about this problem with the number of lots, or does he deny knowledge that he knew in January and February about the reduction in the number of lots that was going to reduce the price for his client if his client granted the extension to the party who had the option contract.
And the record does contain, if I recall correctly, emails where Mr. Chrisman was made aware of this in the summer of 16. Is that correct?
Well, again, what he was made aware of in the summer of 16 was that under the deal that he had granted the extension for, he was going to recover less money than he thought he was. What he did not know in in the summer of 16, and he didn't learn until after November of 16, was that his lawyer saw that coming 6 months beforehand when Mr. Chrisman had an opportunity to get out of the first transaction and make a better deal, and his lawyer didn't tell him about it.
Counsel, when did he learn that Mr. Solomon was aware of this report?
His affidavit testimony is he didn't learn of it until after suit was filed. Suit was filed in December of 2016. I believe this matter came, and I wasn't representing Mr. Chrisman in the underlying action, but I believe his attorneys discovered it in the course of requests for productions and seeing the email correspondence between Mr. Solomon and Mr. Parks, the putative buyer under the first contract.
Your assertion is the fraudulent concealment claim statute of limitations time period doesn't start running until that point, that moment of discovery.
That is exactly my argument, Your Honor, yes. And what we have in support of that is, and it's cited in our brief, the Story versus Bunstein case, where it was a case not unlike this one, where there were several different legal malpractice claims that were lodged against an attorney. And the trial court and the Court of Appeals both found that because the plaintiff client was aware of some of the legal malpractice claims, basically that set the accrual date for all of the plaintiff's legal malpractice claims. Supreme Court reversed that analysis and stated that when you have a legal malpractice case that raises more than a single legal malpractice claim, a separate and discrete legal analysis, accrual analysis, is required for each claim. And that is exactly what was not done here. What the trial court concluded was that because of Mr. Chrisman's rather unspecified complaints in October and November of 2016 about his lawyer not treating him right, his lawyer having a conflict of interest, the trial court erroneously applied a one-size-fits-all analysis and concluded that if Mr. Chrisman was aware a month or two before the deadline that he had issues or beliefs that there were some unspecified or unconnected results to the January transaction, it didn't matter that there was constructive knowledge for all of the claims. And that's directly contrary to Story versus Bunstein, and it's also directly contrary to the idea that fraudulent concealment tolls the statute of limitations. That's what Story holds, that's what the Supreme Court held in the Red Wing case, and Story even cites the applicable statute on that. I believe it's 28.3104C2, which explicitly tolls the statute of limitations in a fraudulent concealment case until discovery. Yes, the statute is 28-3-104, paren C, paren 2, which within that savings period for a fraudulent concealment claim, it specifically includes legal malpractice cases or claims against an attorney. So that's the first issue. The second issue that we raise on appeal is the trial court's dismissal of the respondeat superior claim against the defendant employer, SP Title. Trial court found that even though SP Title had admitted that the actions taken by Mr. Solomon with respect to Mr. Chrisman were within the scope of his employment and his agent for SP Title.
Counsel, were they legal services that were being provided in that capacity?
Yes, they were. And that made a difference to the trial court. I suggest that it should not, that it wouldn't matter, it doesn't matter if the employer was a title company, a law firm, or a grocery store. If the employer has delegated someone, doesn't matter what the person is, but to do business that is of benefit to the employer, respondeat superior applies. Thank you. I think I've used up my first 13 minutes. Thank you.
Thank you very much.
Good afternoon. I'm Ryan Simmons, representing Keith Solomon and SP Title in this action. We would ask that the court uphold the trial court's granting of summary judgment for the malpractice, for the statute of limitations of the malpractice claim, as well as the dismissal of SP Title at the lower court level. This case specifically focusing on the accrual of the statute of limitations, and specifically whether or not there was enough knowledge imparted upon Mr. Chrisman of the potential malpractice or alleged malpractice claim. Under a constructive knowledge theory, the statute may begin to run whenever a plaintiff becomes aware or reasonably should have been aware of facts sufficient to put a reasonable person on notice that an injury had been sustained as a result of the defendant's negligent or wrongful conduct. Constructive knowledge does not require that the plaintiff be fully aware of the entire nature and extent of the injury, nor must the plaintiff actually know the specific type of legal claim he or she has, or that the injury constituted a breach of the appropriate legal standard. Instead, the plaintiff is deemed to have discovered the right of action if he's aware of facts sufficient to put a reasonable person on notice that he suffered an injury as a result of the wrongful conduct. Is knowledge of facts sufficient to put a plaintiff on notice that an injury has been sustained, which is crucial. More specifically, plaintiff's been found to have constructive knowledge where he has information sufficient to put a reasonable person of the need to investigate the injury. Facts known to the client even before the alleged malpractice occurred may be considered as part of the totality of the circumstances when determining the client's knowledge of the injury. Tennessee case law establishes that an individual has constructive knowledge of his attorney's wrongful act when the
Let me interrupt you for just a second.
Yes.
I'm assuming that from where you're going here, you're going to inform us, or you're going to tell us that from your client's perspective that Mr. Chrisman had constructive notice.
That's correct.
And my question is, when did he get that constructive notice and how did he get it?
That's a interesting point, and that's something that was discussed at the trial court level. So I would posit to the court that it's obviously arguable, and it will be argued by the other side as far as when that was raised. However, in June of 2016, there was an email sent to Mr. Chrisman that went through and identified when this reduction of the lots occurred. And as part of that email, there was also the traffic study that was attached. And the traffic study went through and identified that numbers had been taken in December 2015 as part of this initial traffic study that Mr. Chrisman went through and has said that he was not necessarily aware of as far as the concealment of that. So from the appellee's standpoint, we would go through and posit at that point in time, he was at least placed on notice that there was at least a need to go through and to investigate the injury, because at that point in time, he's gone through and received the reduction in lots and also the reduction in the purchase price as a result of that.
Counsel, how does that communicate to him that his attorney was aware of this months earlier? So he may be aware of the report by then and
Right.
the reduction, but how does that make him aware that Solomon was aware of this 6 months earlier than he became aware of the report?
So that's an interesting point. At that point in time, again, we would go through and posit that that's the point in time in which he has enough knowledge to go through into the need to investigate. How did this come about? Why am I just learning of this right now about this reduction?
Doesn't fraudulent concealment, though, flip the script here? If Mr. Solomon is engaging in fraudulent concealment of the fact that he was aware of this information, instead of Mr. Chrisman being on inquiry notice that he should be looking into it, isn't the statute of limitations extended essentially until either he becomes aware of it or he should have become aware of it?
That's an interesting point. And as far as that, I think in our brief, we've gone through and touched on that to go through and to identify that this fraudulent concealment tolling doctrine was not necessarily raised during the summary judgment argument. So I believe the other side's gone through and mentioned that it was potentially raised in passing, or at least mentioned in some minor capacity. But it's our position that it was not necessarily raised and fleshed out that this fraudulent tolling doctrine should even go through and be raised. And so we would posit that fraudulent tolling doctrine should be waived as a result of that. It wasn't necessarily fleshed out until this brief was filed. And so that's when the other side's gone through and recognized that this doctrine may apply.
Let's assume, just for purpose of argument, that it's not waived here. And do you have an argument on the merits in terms of why the fraudulent concealment doctrine would not mean that this was still within the statute of limitations? Or if the doctrine's applicable, is he within the statute of limitations related to the fraudulent concealment claim?
I don't know that the other side has gone through and identified any intentional evidence of this withholding. There's nothing in the record that I'm aware of that goes through and identifies that this has been intentionally withheld from Mr. Chrisman. So I think that's part of the issue there, is that it hasn't necessarily gone through and met all the required elements for that tolling doctrine to apply. And I think we've pointed that out in our brief as well.
Let me ask you one other question.
Yes.
And I was looking at the email that you referenced. I believe it was on June 15th of 2016. And it's your client's position that Mr. Chrisman should have been on notice, or at least some type of inquiry notice from that time. However, in looking at that email, it appears that the report of the traffic engineering firm, or the group that analyzed the traffic study, was done, and there's a letter attached to that email from the engineering firm that it's dated June 15th of 2016, and it makes a statement that the analysis was done based on the Williamson County zoning ordinance, which was revised in June of 2016, and traffic counts which were collected in December of 2015. So what about this puts Mr. Chrisman on notice that anything has occurred prior to that? If we look at the face of this document that was obviously in the record, what about this document should put Mr. Chrisman on notice that anything was transacted or there was any exchange about this information prior to the time that this email was done? Because it appears that the email informing him and his attorney of the results of the traffic study is dated either the same day or a day later possibly than the actual traffic study report attached to it.
Right. So within that email itself, I believe there's language going through and identifying that this could have been so much worse. Going through and identifying specifically that this could have been worse in terms of, I guess, the reduction in lots. But also just the reference to the December 2015 traffic counts are specifically also something we would go through and identify that would, again, place somebody on notice that there was at least some sort of knowledge beforehand that this had been conducted at the time.
So you're not relying upon any other, or let me rephrase that. There's no other evidence in the record that you would point to say that Mr. Chrisman should have been on notice. You're saying it came from this email?
Well, I'm saying that in addition to all the other communications that Mr. Chrisman had in September, October, and November 2016, that at that point he begins to question his counsel's decisions. He begins to question what the motivation was for his counsel at the time. So all of those collectively would just go through and be kind of the icing on the cake, so to speak, for his need to become aware, to go through and investigate what's going on at the time in this traffic study that was.
But you're not pointing to anything prior to June of 2016?
No,
right.
Correct.
Thank you.
Correct.
Counsel, with regard to the respondeat superior issue, it seems like the trial court judge in this case, and correct me if I'm wrong in my understanding, but seemed to be saying legally the legal services provided could not be controlled by a non-lawyer business entity, and therefore the claim had to fail. Isn't this instead a matter of fact rather than law in terms of if a business is controlling legal services, why, and they shouldn't be, violation of rules, but why does that exempt them from liability? Because, and they're engaged in, the lawyer's doing something they shouldn't be doing under the professional rules, business is doing something it shouldn't be doing, but how does that exempt them from liability? I'm a little lost on that.
So I think the trial court went through and pointed to the rule of professional conduct as it relates to that, to identify the scope of what was to be expected. And so I think that, reading into the trial court's opinion, appears what they've gone through and done is to identify the scope of the services to be provided. And because Mr. Chrisman was aware that Mr. Solomon and Mr. Parks were, I guess, partners, even though one was a lawyer and one wasn't, that potentially could go through and be inferred that the scope of the representation there could not go through and allow for this to take place. So
Mr. Chrisman asserts that Mr. Chrisman in his capacity with SP Title was engaging in legal services, if I'm correct on his argument. If that's factually true, not whether it should have been true, whether it's consistent with the rules of professional responsibility or not, but if it's factually true, doesn't his claim still survive? Then, as a matter of fact, if he's trying to raise a legal malpractice claim connected to services that were legal services, or are you saying they're business services, not legal services?
Well, I think that's the distinction the trial court went through and made, is trying to figure out exactly what services were being offered. So the engagement letter that was signed by Mr. Chrisman at the time between Mr. Chrisman and Mr. Solomon went through and identified that Mr. Solomon was going to provide this representation, not necessarily SP Title. So that's another distinction we go through and provide. That's a fact in the record that identifies this engagement was between Mr. Solomon and Mr. Chrisman, not necessarily between Mr. Solomon, or excuse me, not between Mr. Chrisman and SP Title, if that provides any clarification.
But that's not the basis upon which the trial court dismissed that or ruled in granted judgment with regard to that claim.
Correct. There was not citation to that fact, but I think that is an important point for the court to be aware of in relation to that aspect. Getting back to the constructive knowledge argument, kind of what I alluded to earlier in regards to Judge McGee's questions, there was a number of communications in October, November 2016 that went through and identified that Mr. Chrisman was aware of these issues with Mr. Solomon's representation, including reaching out to other people outside of counsel, reaching out to an additional attorney, going through and asking about these issues at the time. So at that point in time, going through and reaching out to additional counsel about these issues, going through and stating that he questions the representation, questions the motivations. At that point in time, there's more than enough knowledge to go through and to impart upon the clients who conducted some sort of investigation.
Counsel, how does that tell him, though, there was a report in January that his lawyer knew about that he didn't tell his client about? And I can see that you start investigating and you realize there's a serious conflict here. There's a problem of that nature. But how am I going to know that there's this report in existence that my lawyer was aware of in January 2016 that he, or I might be getting my years wrong here, but that he concealed?
Yep, good question. So again, I think with the totality of the circumstances, having all of these questions in addition to this June email would place a reasonable person on notice to go through and to investigate those issues, to go through and to scrutinize, to the extent he's gone through and questioned already, almost everything regarding the representation itself, in addition to the large reduction in price there. So to the extent that it goes through and looking at it retrospectively, the appellees would go through and assert that all of these facts, all these communications would cause somebody to go through into a reasonable person for the need to investigate these issues. And so.
And I have a question about your tolling agreement. That was signed in November of 2016?
I believe it's 2017.
2017.
November 2017.
And at that time, what was the scope of that tolling agreement? What basically did it prohibit? I'll say it that way, as far as causes of action.
I don't know that it prohibited necessarily anything within the confines of the tolling agreement itself, but it did provide for any applicable defense that may be asserted is not necessarily effective until November 27, 2017, I believe is the date. So any potential defenses that could be asserted before that point in time would be applicable at that point in time. We've gone through in our argument and also cited the Honeycutt case where there was actually a client who had constructive knowledge of her attorney's alleged malpractice, where the client had questioned the attorney's previous advice, met with another attorney about the case, sent communications expressing displeasure about the representation, and then discharged the attorney. This court went through and found that there was sufficient knowledge on the part of the client to go through into the need to investigate. So the accrual for the statute of limitations began at that point in time. I see my time is running out. I would go through and request that the court uphold the lower court's ruling, and thank you for your time.
Thank you very much. Mr. Winter?
I appreciate Judge McGee's reference to the document of June 16 and that paperwork, because I think it will serve to illuminate the point that I'm trying to make on behalf of Mr. Chrisman. The documents that Mr. Chrisman received in June of 2016 let him know two things. Number one, it let him know that a traffic study had been done in December of 2016. And number two, it let him know that the Williamson government, based upon that information, reduced the number of lots that he was hoping to get for his property based on that report. What Mr. Chrisman didn't know, and what Mr. Solomon didn't tell him, was that Mr. Solomon and the prospective purchaser knew as soon as that traffic study was done in December of 16 that when the new Williamson County regulations went into place that summer, Mr. Chrisman was going to take a big haircut on his purchase price. There was no red flag. There was no smoking gun. There's nothing in that communication that can fairly be said to have placed Mr. Chrisman on inquiry notice. And I would point out that, and this is in the reply brief, we did raise the fraudulent concealment argument in the trial court. Our opening response to the motion for summary judgment was, quote, "Because Mr. Chrisman did not discover Solomon's fraudulent concealment on the adverse traffic study report in February 2016 until sometime after December 2016, this legal malpractice claim cannot be time barred." And the last point in terms of the respondent superior issue and the rule of professional conduct that the trial court cited, I submit that that rule of professional conduct is to protect the client from lawyers who improperly engage in a partnership with non-lawyers. The purpose is not to protect the wrongdoing parties, the lawyer and his non-lawyer partner. Thank you.
Thank you. Thank you both. Would you please call the next case?
Linda Compton versus